Good evening. This is 7:15. We're at September 18th, 2014.
Good.
Really, that's a good way to start. We're at room 103 at 37 Shattuck Street, Littleton, Massachusetts. This is the Zoning Board of Appeals, and we will open the meeting. 7:15, we're scheduled to take up administrative matters. Minutes is the first thing on the agenda, and we are several meetings delinquent in approving our minutes. So
Under
I hope-
administrative matters, can I bring up something?
Yeah, after we do minutes.
Oh,
I'm getting
okay.
to the minutes, no matter what.
Okay. Well, just real quick, I wanted to mention, I'll shut up.
Go ahead.
It seems silly to be scheduling these hearings every 15 minutes when there's no way we're going to have gotten through 4 subjects by 8:30, and yet we have a gentleman coming at 8:30 to sit here and wait while we get through it. It seems like we should be scheduling them on the half hour. If we have to wait 5 minutes, so be it.
We've been through this for several years, and by trial and error, 15 minutes works the best, because some of the hearings fall out, and as the chair, I have the prerogative of not letting everything delay. We can stop a meeting in the middle and bring someone else in and through. So after a lot of years of experience, this 15-minute time, maybe 20 minutes would be a compromise, but the 15-minute time works out. It's very, very seldom that we end up with long, drawn-out hearings. And we'll see tonight how it goes, but
Let's look at it tonight, because
Then-
we've never taken a case that's taken less than 15 minutes.
could we just move to the minutes now, please?
Yes, Sasha.
Thank you.
January 6th?
I want to start with January, and I took the Liberty One meeting that you weren't here, Bill, of actually redlining and asking her to retype with my red lines, so I hope you've
And that was
just
supposedly the
reviewed
latest draft.
the latest draft, because that should be, whatever we all have should be the latest draft, and now I would like to hear comments from everyone else. Go ahead.
Oh, is that with anybody else?
Go ahead, Jim. Bill.
All right, the second paragraph down, this starts Chair Gould asked Jeff Yates. Second line, Jeff Yates reported to the subcommittee, which includes himself, remove the comma, and Alan Bell, then with consultant Ed Marchant. Sounds like Ed Marchant is one of the subcommittee members,
Thank you.
and that's all on page 1. Page 3. And it starts with will contain 96 units as rental in perpetuity. Next to the last line of that paragraph, and it starts out far out of what building code allows, they should be changed to town's zoning bylaws.
Where are you, Bill? Oh, page 3, I'm sorry.
Because we were talking about the zoning bylaws, not the building code.
I still don't see where you are on zoning bylaws, please.
Third page,
Yeah,
1 to 3.
building code allows. What zoning bylaw allows?
Yeah, instead of building code allows, it should say, of, far out of what town's zoning bylaws allow. When you get down to the next paragraph, Town Administrator Keith Bergman stated from a public policy standpoint, they should require the applicant to come back to future zoning board meeting. If a lot of tenants can't afford to buy, they should have a say. What are you talking about? I mean, the whole thing is kind of broken up a little bit, and,
I
a
think,
lot of tenants can't afford to buy. In other words, if you can't get people to buy, then who should have the say?
I think Mr. Bergman he didn't say if a lot of tenants can't afford to buy, he said he assumed a lot of tenants wouldn't be able to afford to buy the unit they're occupying if it goes to private ownership, and that those tenants should have a say in that decision and have an opportunity to voice their opinions.
I think your point is taken, though, both of you, that there's a missing sentence, and it probably needs to say,
Well,
discussing whether the units should remain in rental in perpetuity.
Yeah.
Discussing whether units should remain.
You can always go back and double-check the tape and see what's on it.
Town administrator stated from a public policy standpoint, they should be required.
It should say the board.
No, the applicant should be required I say the board should, you're right. The
Should
board,
require?
the board should require the applicant
Yep.
to come back,
To
we
future
don't even have to
zoning
say,
board
don't even have to say the
hearings.
future zoning board, to come back.
To the zoning board.
Yeah,
And he stated his reasoning was tenants may not be able to afford to buy the units and should have the opportunity to voice their,
No,
Board-
he doesn't want the tenants to have an opportunity, he
Board
wants a
should.
future board, so I'm just going to end it there.
Yeah, okay.
Town admin is discussing whether units should,
actually, he did say he wanted the tenants to have.
No.
no, they don't
No,
have
no.
a say.
If they can't afford to buy, they don't have a
Discussing
say.
whether,
Yeah.
discussing whether
They may not have. said
units
it.
should remain rental in perpetuity. Town Administrator Keith Bergman stated from a public policy standpoint, the board should require the applicant to come back
To a future,
for a modification, That's it.
okay.
Okay, next.
All right, down, same paragraph, third line up. The board's consensus is all, not all rental units, but all listed or proposed rental units should remain rental.
Well, what's the difference? Consensus is that all the rental units should remain rental.
Because if you say all rentals, it's got to be rental and 25%. I don't know.
I don't understand the
Okay,
difference.
All right,
If all rental
Well,
units
keep
should
on
remain
reading
rental.
it, yeah, because it's basically saying that if units are sold, 25% of them have to be affordable.
Yeah, so all rental units remain rental, and
Okay,
25% of all
okay.
units sold have to remain affordable.
okay.
Okay.
Next paragraph, the board discussed the waiver list. The majority are the same. Majority waivers?
Of waivers did not change.
Yep. Majority waivers.
Thank you.
1, 2, 3, 4, 5 lines down, same paragraph. Chair Gould stated, "You have 4 votes." Who's the "you"?
Applicant?
Applicant.
Okay. That's
I
it.
really shouldn't have said 4 votes, but did we poll, does it say we polled the
You
board?
told
Yeah.
that you
Yep,
did not get
yep.
votes. Or
Two
it
votes
would be
stated.
more appropriate to say you have four
After-
members in favor of.
Yeah. I think we should say that. Chair Gould stated, applicant,
And not in favor of the height, but not opposed to the height.
Chair Gould stated, applicant has 4 members leaning in favor of the height. How's that? Is that all right?
Yep. Okay.
So the board can vote now or continue the way of discussion to the next meeting. Is that all right now? Anybody have any other comments to those minutes? I'll entertain a motion to approve those minutes of January 7th.
Motion to approve
Second, please.
as noted.
Second.
All those in favor?
Aye.
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 2, 3, 4, 5. All members are here. Okay, next set.
Which,
Bill, the next set is on you because I recused myself from both of those hearings. So that would be the minutes of May 22.
What about March?
Yeah, March 3rd.
March 3rd.
March 3rd.
yeah. Okay.
That's fine, okay.
All right. Under administrative matters, second paragraph. Chair Gould appointed Alan Bell to be the 5th voting member. Asked if any board member would be interested in the committee. You know, the two things don't run together.
Yeah, it does, because
should be
we
two
had
separate
only
statements.
4 people, we had only 4 members, so we needed an alternate to vote, and then to vote on who would be nominated to the subcommittee.
Right, right. Should be 2 sentences, though. That's what I'm saying. Right?
All right, so the
Two
fifth
different
voting, so the 5th voting member to choose a representative, right?
Okay, yep. And
She
Chair
then
Gould
asked,
if any board
okay, she then asked if any board member would be interested, and Jeff, we all stood back, so it looked like Jeff volunteered.
What did I do?
We all pushed our chairs back, so it looked like you were volunteering.
Okay. 15 Great Road, third paragraph down. Patrick Joyce expressed concerns, yada, yada. Third line down, where it says, "Are a breeding ground for crime and undesirable tenants." I would like that particular part of the statement taken out of here, because it does say previously, Patrick Joyce expressed concerns about the 3 apartments. I don't think we need to have it as a breeding ground for crime and undesirable tenants.
I would
shows a
defer to Patrick
prejudice.
Joyce, but that was his statement.
We
He
don't
was
need-
very adamant about it, and that's all she's
We don't-
reporting, is that that was his concern.
Are you looking at the March 3rd meetings minutes?
You decide if you want it in or out in perpetuity.
I'd like it in.
Okay. That's what he stated. She was quoting a comment.
Okay,
Thank you.
same thing, same paragraph, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 11th line down, status of expensive. Sentence, says, Cheryl Hollinger wants wording in the decision that the applicant come back with a totally different, I would suggest that we have, wants wording in the decision to reflect that the applicant came back with a totally different project.
I'm all right with that. I don't- it's-
Okay.
It's the same thing. Wants wording in the decision to reflect.
Yeah. Okay. Next.
Second page, after the votes and everything else, Cheryl Hollinger read the following statement. I don't understand this being in here.
That's her.
I asked it to be read
She
into the
asked it
minutes.
to be read into the minutes, and we quoted it verbatim. She was asked to
Okay.
repeat it.
All right,
Thank you.
I mean, it was so long ago, so.
Yeah.
All right, okay.
So that was March 3rd minutes. I will entertain a motion to approve.
I make motion to approve March 3rd minutes
I second it.
Motion, as noted,
as
amended.
amended. Thank you.
Patrick, I don't think you can
No.
second only because you're not a voting member right tonight. You can't second on the
I'll
minutes,
second
sorry.
it. I'll second it.
We're glad to have your opinion, though. After all of yours.
And all those in favor signify by saying aye.
Aye.
And that's number 2.
We are at 8:30.
Yep.
So
Okay,
2 more
I'll hold
minutes.
I'll hold another set of minutes. Bear with me because I'm taking minutes tonight too, so everybody just bear with me if I'm going a little slow.
It's being taped, so Michelle can transcribe from.
Yeah. Okay, we have one more minute left, and the first hearing that we have tonight is a 7:30 hearing. If you wait 1 minute, I'll call it.
Yeah, you want to hold off on the May 22nd one?
Yes, we won't be able to do that in 1 minute, I don't
Yeah.
think.
Take the minutes to organize our minutes.
Do you have a folder for that, this one?
Do I have one?
Have the folder?
Yes, I do.
Shelley gave me 2 sets, so I don't know if it one belongs in the folder.
Oh, I don't think so. It's right there. It's in there.
That's it, okay.
Okay. Okay, it's 7:30 PM. I will call, open the hearing for 10 Emerson Drive. It is case number 837A. It's being presented by John Croteau for a special permit or a variance from section 17310B1 for a proposed deck. Mr. Croteau?
Yes.
The way we handle our meetings, I think you've been here before, but you come forward and you tell us your case, what you want to happen. We hope that you'll give us enough information about the lot and the size and what you're trying to do. After you're done, the board has questions, the board will ask questions. After the board has questions, we'll then ask any participants or members or comments that we might have received by the mail, and then you will have a chance to respond to anything. And then, if there's any explanation, we'll take it from there. After that, we'll close the hearing and we'll vote. Okay? So you can do it formally or informally. If you have things to show us, step forward. If you want to present from there, that's fine.
I think you should have a package with everything that I've got.
Okay?
So I'm looking to add a deck onto the side of the house, and it's a non-conforming lot. And I've spelled it out in the letter that I submitted, why it's non-conforming, because of the size and because of some of the setbacks. Do you want me to go over those?
Yes, please.
Okay, so the existing house is okay, it meets all the setbacks, but the detached garage is 2 feet from the side and 9 feet from the rear of the property. The lot size is 6,000 square feet. So when I hired the architect, we're looking to put a deck in because I've got a backyard that's fenced in. And just to have easier, safer access to that backyard, I wanted to put a deck from the kitchen, because right now the only way to get into the backyard is to go through the kitchen, through the mudroom, out the side door, around the building, through the fence to get into the backyard. If I put the deck in, you'll go through the sliding doors, down the steps, and you're into the backyard. So it's a lot safer. The only problem is non-conforming because of the size of the lot, small size of the lot, and I couldn't put the deck in the back because that's where the septic system is, so the deck would be sitting right on the leach field. So there was those issues, that issue as well. So that's why we felt that locating the deck onto the side was the best place to put it, the best place to put it based on what I have to work with the yard. And I think that's about all that I have to say. Yeah, I think that's all I have to say. Yes.
Questions? Cheryl, go ahead.
Now, I noticed that your backyard is very raised and has retaining walls around it. That's because it's your leach field, correct?
Yes.
Will this new deck be on the same level as that raised yard?
It will be on the same level as the first floor and then step down to the level in the backyard
And how will it do that? Could you?
with
could you
6
walk-
steps.
I see, but will it, and is there a gap it will cover between the backyard and the,
Not sure I follow that.
I think the question is, can you get from the back of the deck directly to the backyard? Or will there be a railing on the back of the deck?
No, you'll go right from the deck right to the backyard. Yeah.
It is an we drove by there this evening, and I'm familiar with the property. It is an awkward backyard.
Right.
And awkward to get into. It does put you within 7 feet, 4 inches of your neighbors, though. Have you talked to your neighbor?
Not since I've applied for the special permit. I have talked to them. I haven't talked to them about this issue because when I talked to them, I didn't realize that there was the setback issue. So, no, I have not talked to the I'm assuming you mean the abutting neighbor? Yeah.
On this side. I mean, it seems like an excellent way to get use of that raised backyard. But, there we go.
Okay.
How will you get, I'm turned around, okay. Can you tell me how close your neighbor's house is to this sideline, approximately?
From what I can tell, looking at it, I would say they're probably a little more than the 15 feet.
Not much.
Well, it's a same size lot of,
They're very tiny in their wider house.
yeah.
Small.
But it just feels like it's a little bit, not a lot, but a little bit more.
Okay. Any other questions, board members?
Just clarification, that the side of the house is 15 feet from the property line,
Yes,
8-foot deck proposed,
yes,
and it will be 7 feet from the side property line.
Yes.
Just clarification, that the purpose of this deck is so you can get out of the house and into the backyard.
Yes.
How did you come up with an 8-foot wide deck rather than, say, a 4-foot standard deck or a 6-foot deck? Because
I
7
didn't-
feet is getting close. If you go 6 feet, you get 2 more feet.
If I could speak to that, I just built a front porch for my mother, and we built it 6, thinking it was more than adequate, and I cannot get her walker around a chair on the front porch. So if you have seating there and somebody's sitting in the chair with their knees hanging over, you're going to be doing a side step. So you can't really enjoy a deck that's only
6 feet wide.
6 feet wide.
Also, if you want to put a grill out there,
Right.
you're in trouble.
Right.
Well, I will put the grill in the backyard, not on the deck, is what I was thinking of doing. But the
But we have to think
architect,
of beyond you living
yeah,
there.
the architect proposed this size deck, so I'm assuming that they were looking at what would be a
Okay.
safe and
Let
comfortable
me-
size.
Following my line of thinking and everything else. Did the architect, and maybe something you can't even answer, but you do need to go back and check with him. Under the state building code, there were provisions in there, certain categories, that, normally it says 30 feet between structures. That's why the zoning says 15 feet from the property line. Okay? Then there's another category in there, and it goes 0, 5, 10, and 15. That certain provisions have to be made for fire protection or whatever else. Do you know if the architect took into consideration that at the time he designed this deck?
Actually, Bill, that's the kind of thing you say that's not the board's.
Well, I raised the
Yeah,
question
board's
because if he goes
purview.
back to get a building permit based on what we have
Well,
and find out it's going to make a change, then he may have to come back in.
Well, the architect may have to do that. He can't answer it here, and it's not within our purview. He knows whatever we decide here, he's still subject to getting a
I know what you're
building permit.
asking, and I know I've asked that, made that statement before, but in the write-up that was given us, they only said for just to get access to the back of the yard. So I just wanted to ask the question. And-
Okay.
But we could approve a decision that gives a specific setback from the property line for the
Yeah,
deck
which
without
we-
referring to the size of the deck.
Yeah, which we would do.
But I guess my other
Can I
question,
just address Bill for 1 second, Bill's question? So you're worried about access to the backyard?
Well, that's what you said, it says for access only, it's not for seating. I mean, if you want seating and whatever else, I
There
mean,
will
8
be-
feet is definitely is
There will be
minimum.
access to the backyard from the other side, so if, and that's
Yeah.
not going to be blocked, so there's plenty of space to get to the backyard from the right side.
Okay.
I don't think that was where he was
Oh,
leading.
okay.
I'm sorry, I think you heard him.
I've heard it wrong.
Yeah.
One more question. On the plans, it's penciled in and marked the house at 15 feet from the property line, okay? Has there actually been surveyed, and do you know for sure? Because I've seen a lot of people take these mortgage inspection plans and just scale off, and they can be off anywhere up to 5 feet. So when we do our decision, if we do approve and put in there a size to the deck or a
This
certain
isn't a
distance,
mortgage.
that we got to be careful that,
It wasn't the
This isn't a
mortgage,
mortgage,
this is
I
this
think.
was the drawing for the new septic, which
but,
is all to scale.
but it, okay, based on previous experience, dealt with this for many years, even septic designs are not accurately located unless they put a number on there. So that's what I'm saying.
Not so anymore. They have to do a survey for the septic
But
design.
they're located if they have to put it, okay.
well, I'm with Bill on this. There's nothing on this drawing that would say exactly
Yeah.
what the setback was.
So I think that we need to be careful.
So it may very well be non-conforming, which in a perverse way, then you're in a special permit situation instead of a
Yeah.
variance.
But also too, if, it depends on how the decision gets written, and how the wording is, that we gotta be careful, because as you just mentioned, Mr. Yates, that we could say not to be closer than 7 feet to the property line. If it actually gets surveyed, that may be a little bit different. I've seen some of these plans actually come in anywhere between 5 and 10 feet off. So I'm just, usually, in fact, our instructions for application says you have to have a plot plan by a surveyor or an engineer with actual dimensions on there. So, right. Those are my questions.
the applicant is aware that he's asking for a change, extension, or alteration to a pre-existing non-conforming property.
Yep.
He and his architect are both aware that they're asking for a deck 8 feet wide. The board is concerned about setting a minimum variance from our setback, our side setback bylaw. The applicant's aware that he has to get the building permit, so he's got to satisfy the building inspector about distance between structures. And he and the engineer are aware that they're going to measure. They have to measure in order to get the deck approved for final certificate of occupancy. So the one thing that, I don't want to frighten
Yep, yep.
him and think that this board is unforgiving. The one thing that you're all concerned about is that when we word the decision, we don't word it 6 inches off so that he has the problem of having to come back to the board again. Cheryl points out accurately that he's using an engineered septic plan. He's not using a plot plan.
But-
You're
And
very,
relatively reasonable.
yeah, and you're very correct that plot plans are as much as 5 or 10 feet off.
But even on this engineered septic plan, they are still not accurate for the location of structures or anything else.
That's correct.
Especially septic
That's
systems.
correct.
They don't come in and say, yeah, we're going to verify what the distances are. So,
That's correct. The lines are
therefore,
surveyed.
with the
That's
absence
correct.
of any dimension on there, we got to be careful when somebody is actually trying to scale it out.
Okay,
I got one more question.
yep.
It's mentioning here there's an architect. Who is the architect? And is he really registered architect? Because a lot of designers out there,
I have stamped drawings, it's with Livingston Lumber, and I've got stamped
but
drawings.
this Littleton Lumber is stamped by a registered architect or just by
They have
Littleton
they
Lumber?
have a team of architects there, and I'm using them for this project.
All
So,
right, so still,
so Littleton Lumber is an architect,
no,
but
they
they're
are
not surveyors.
No, legally and technically, they are not an architect.
No, they have an architect on staff that's a registered architect.
If they stamp it as registered architect,
Yeah.
everybody else.
Okay,
Okay.
we just don't need to be contentious. We have,
No, I
we've
know,
laid
I know,
out, we've
but-
laid out the issues, applicant is aware of them, and we don't need to be contentious. It's going to be a long night if we do
Yeah.
this. Okay, we have any abutters in the room who would like to speak to this application? All right, there is a memo from the building inspector, 10 Emerson Drive. Applicant is seeking a special permit from the Littleton zoning bylaws, 173-10B1. It is unclear if the existing structure is non-conforming regarding setbacks, as the plot plans are not to scale and they are photo reproduced. This matters in that I cannot determine if the applicant is intensifying an existing nonconformity or creating a new nonconformity. Special permit versus variance. As a side note, the front porch has no permit on record in the building department. No further comment. Now, that leads me to a question I wanted to ask you for all the hearings tonight, Bill. We've gone back and forth as to whether or not creating a new nonconformity requires a variance or a special permit. And most recently, you shared a case that is the latest and greatest on that. Will you share that with the board,
I haven't
please?
seen that case. I don't know if you could open that email. I have asked for a copy of it, and I have not seen it. I've heard of a reference to a case where the land court has made that decision. I haven't seen it.
What decision? Can you just reference it?
Diedrich versus, oh, it's called.
No, I mean, what is the result? What's the conclusion?
The result says that now if you have a non-conforming lot, a non-conforming structure, and you want to make a change such as an addition that creates a new non-conformity, then a variance is required.
Okay, so,
Previously to that, the Gale case says, now any non-conforming lot or structure, then it's always a special permit.
okay, so let's go
But
through.
I don't know the details of that.
Okay, so let's go through, speaking to Roland's letter. First, I want to see if the publication contained a notice that it could be either. And if it's so, then we'll go through the requirements for a variance and make sure that the applicant satisfies them.
Well, how we deal with the special permit or variance? I mean, so far up till now, we've always, because in the other case, we've dealt with all of these as special permits. The board has
Well,
not made a determination.
The other thing you might want to consider is that the building inspector may require you to get a building permit plan, since this isn't scale drawing. I don't know if you will or not. That would have solved all of these questions.
So I would request that the board treat this as an application for a variance because he is creating a new nonconformity. I suggest to the board that he has indicated in his letter and in his presentation that there are sufficient factors to satisfy the requirement of the variance. That is, that owing to lot shape, size, or topography, there exists a hardship in that he has very limited enjoyment of the outside of his property and a safety feature on having to be able to get his family from the front of the house to the rear of the house for enjoyment of the backyard. So I suggest that he meets the requirements for a variance, and I would ask the board to consider it as a variance so that we don't have any issues later on, that he doesn't have any issues later on. I would question whether the board wants to include in its decision a request or a requirement that he get his front porch permitted at the same time.
The front
No?
porch is brick and very old and looks,
That's coming down.
Predates it.
it looks very original. It looks like it's 1940s.
It's coming down.
The front, you're taking the front deck off? It,
There's no need to include it.
there we
Okay.
go. I was gonna say, it looks like very much original.
Anybody want to move to close the hearing? or-
No, I didn't.
What?
I don't want to get contentious, but if you go to a variance and they're asking for relief of particular regulation or bylaw, I go back to the original question I had earlier, that in the written information given with this application, this is just for access from the house into the rear yard. If you ask for a variance, it gets more important, like to minimize as much of the encroachment into the setback, beyond what is required, so that if that was the case, then I still would think a very valid question would be, why could this deck not be 4 feet or 6 feet rather than 8 feet? If it's a special permit, then it's not as important.
At no point does his letter say that he doesn't want to use the deck for other means. He does state the deck provides easier and safer access, but it doesn't say, I'm not going to sit on it. I'm not going to put a grill on it. I'm not going to use it. I mean, to hold his feet to the fire over the fact he didn't say, I want to have room for chairs there, it kind of, most decks have room for chairs.
How about if we pull the board? Mark?
What's the
A
question
couple
that-
questions,
what's the-
whether you think we should treat this as a variance or a special permit?
Actually, based on the argument that he wants access to the backyard, I do tend to agree that what does a 4-foot deck not accomplish? Why an 8-foot deck? Safe and access to the backyard is, to me, a reasonable request. A structure just so I can sit out there, it's nice, but I don't consider that necessary or valid argument. So an argument could be made that a 4 or 6-foot deck or walkway would accomplish its purposes.
Jeff?
I don't mind the 8-foot deck. I think on this site, you have this big structure in the backyard, these walls, and you've got to retain the soil and everything. The deck seems to relate to that, and I don't mind it.
You think we should treat it as a variance or special?
Well, I don't think the 4, 6, or 8, I think if it is subsequently shown that this is a non-conforming structure already, then this whole argument is moot, because it's a special permit and we would be more relaxed about it.
It is clear to me it's already non-conforming. It's non-conforming
Well,
in
not
lot
conforming
size and frontage.
on that particular setback. That's what it
And
is.
the garage, on
Yeah,
that
no,
side.
there's
you
many
mean.
nonconformities.
On that
but-
side, you mean,
But
okay.
it's presented to us that the one, that the side that we're granting this relief from is conforming. And, I can scale this and sort of, it looks like it's probably about 15 feet. The mortgage plan shows that it's not, but this shows that it is.
So that makes you want to do it as a special permit or? a
No,
variance?
then I would want to do it as a variance. And I don't know how, I guess I don't have trouble with the 8-foot deck regardless.
Okay. John?
Well, over the years, I've always had a problem with people coming in without a certified plot plan. Because what Bill is I think was trying to get at was that you're speculating as to how far he is off this property line. Okay, so he could be closer, he could be further away. So we're guessing as to what we're doing here. And you could get to that point where you grant the variance or a special permit. I still feel that the board should require certified plot plans so that we're actually dealing with the raw numbers.
Yeah. I agree with what Ms. Cantino said. Without, instructions are very clear on any of these applications. Without the numbers, we do not know specifically and totally what we are dealing with. We don't know if there's a non-conformity on that side of the building. The plan, septic plans without dimension and full inspection plans are just locating a building on a piece of property. There is no basis or no information that tells whoever doing the plan exactly where it is. It could be 10 feet off the property line, it could be 20 feet off the property line. No one knows until the actual survey is actually done. With that in mind, we don't know if we should be dealing with this as a special permit, or if we could be dealing with this as should be dealing with it as a variance. I don't have enough information or uncertainty to be confident and comfortable with taking it as either route at this point with the information that we have in front of us right now.
Cheryl?
Surveyors are incredibly expensive. The cost of having this officially surveyed for just a deck would exceed the cost of the deck. And when you have a, no, I sat and listened to you quietly. When you have a recent septic design, which required a survey being done, and they have to locate where how far the septic is away from structures. And this is a very tight lot. It just can't be off that much. Are we 15 feet 6 inches from the property line? In which case it conforms now, and we need a variance. Are we 14 feet 10 inches? I mean, this is coming up because we are so close to the definition of what is, are you on the property line? Are you have satisfied the setbacks now is the problem, is reason why it is. I think we should grant it as a variance or a special permit, whatever gives him best control. But I also think we should say he must be a certain distance from the property line. And let Roland do his job and make sure it is that distance from the property line. If Roland demands he survey that line, then Roland demands he survey that line. But if we say, okay, he must be at least 7 feet away from the property line, then that satisfies our issues of protecting the property line and the neighbor and being able to get around property, to maintain it, the deck, to maintain it, to paint it, to mow, all of those good things that we try to watch out for. Thank you. Alan?
Yeah, variance or special permit doesn't really matter to me. I think what matters more to me is the issue of scale here. And it seems to me just spatially, I would not be in favor of overwhelming that space there that's already pressing beyond the allowed distance. I would be in favor of shrinking it back to at least half of that size, but it's hard to know what that line is. And it's also hard to know exactly where the other house is. The fact that we don't have abutters here, I'm assuming that people who just came in are not abutters, and they did get notice of the meeting, seems to suggest that they must not have a problem with it. So a little less concerned about that, but I am concerned about the scale there. And I think you could probably do it with 6 feet or maybe even with 7 feet, but it just seems like just the balance of what's going on there, I think would be compelling to not overwhelm that space with the deck.
Right.
This is a deck, not an addition. I don't have any problem with it. And the drawing presented says 15 feet, so presently I think we have to assume it's conforming, and we're making it non-conforming. And if we put something like, not to exceed 8 feet and not to be closer than 7 feet from the property line, something like that, then I would have no issue.
Thank you. And Patrick?
I'm all right with it.
Okay. I'm a little bit surprised at the polarized positions here. I've been sitting on this board a lot of years, And we have to my recollection, very, very seldom denied or given such a hard time to anybody on these small lots in the lake area. Witness the big houses that are going up. Nobody has asked them about the scale to the size of that house with all the new construction going up down there. Here's a man that bought a modest house on a yard that's mostly septic field on a raised bed, and all he wants is a little sit out in the patio to enjoy his driveway. We've resolved these in the past, John, without certified plot plans or scaled plot plans by saying just what was suggested at this end of the road. We give an 8-foot width and no closer to the lot line than 7. And then if he needs a few inches because he made the mistake, then he'll have to come back here next month and ask us to look at it again. But he took the risk not coming here with an engineered plan. I will not argue with you, but tell you that this septic plan certifies that it was taken from a recorded plan at the Registry of Deeds. So boundary line information is accurate. I will agree with Bill that you can't tell accurately where or how the house is positioned on the lot. And if it's canted so that it's not 15 the whole way, you may have a nonconformity at one corner or you may not. There's no way of telling that from this plan. I concur with all of that. Since you're all a little bit less excited about a variance than a special permit, and since we have treated this situation as a special permit request for all the years I've been on the board, until Bill and I read that case and come with a definitive conclusion to that case, I am going to recommend then we treat this as a special permit. That way he doesn't have to satisfy as many of the things, and I'm going to ask the board its willingness to do just what this side of the room suggests, and that is, I think most of this side of the room, Alan, I think you were the dissenter, but 8-foot deck with closer than 7 feet to the lot line. Then he's got to go to the building inspector, he's got to measure it, he's got to have conformity to that decision, right?
So it's up to an 8-foot deck, but no closer.
No
than
closer than.
No closer than 7 feet. And I'm sorry, I went into discussion without closing the hearing, so I'll take a motion to close.
Well, let's just finish this discussion.
Yeah.
No, I'm more in favor of this, based on all the discussion we went about, of it being a special permit rather than a variance.
Okay. So, let's close the hearing. Motion to close, please.
Motion to close.
Second. And all those in favor signify by saying aye.
Aye.
Opposed? None. Hearing is closed. Now, we just had discussion. If we can move it right to a vote, I'll do that. Otherwise, we'll step it back for the next hearing. Anybody have any further discussion? Okay, I'll take a motion.
I make a motion that we approve the
Grant the
grant
As
the special permit as requested with the following provisions, that the setback of the new deck from the property line be no less than 7 feet, and that the size of the deck be no wider than 8 feet. And do I need to reference the plan? Yeah. As shown on plan submitted August 13th, 2014,
Let's just see where you
case
sketch
number
the deck.
83.
No, you want to reference the plan that has the deck drawn on it.
Well, my plan doesn't have.
This one does. Here.
No, it doesn't have a reference.
First one, yeah.
I would just
Submitted with
reference
the application.
submitted with the application, case number 837A.
Second,
Second.
all those in favor?
Aye.
Aye.
Opposed? None. You've been granted your special permit for that application.
I have one question.
Yes.
Do I give the check to
You
you
give
or
the check
do I
to me.
give?
35, 35, 30.
35, 30.
I'll give you the receipt. There you go.
Okay. Thanks for your help.
You're welcome. Okay, time is 8 o'clock. We're at the 7:45 hearing of case number 838A, 123 King Street, Joseph Zagarella, for special permit or variance from section 17368 for conversion to a two-family home. I will say that Mr. Zagarella and I had a conversation or two about the history of this property. but I have no financial interest in the outcome of this decision, nor am I representing Mr. Zagarello. If anyone objects, I will stand down.
Well, I had a Patrick, Mr. Joyce and I had a very brief conversation with Mr. Zagarello this afternoon when we stopped by to look at the property and look at the things.
No, that's perfectly permissible.
Okay.
As long as you disclose everything we
Yeah.
discussed.
Perfectly permissible. Okay, Mr. Zagarello, you want to step forward, please, and tell us what you're presenting?
So I'm here to petition for a special permit to convert my house to a two-family. The house has already existed as a two-family for 32 years. I've owned it for 15. I bought it believing it was a two-family. The assessor's office has it listed as a two-family, which is why I thought it was a two-family. I only recently found out that it's not because of the building inspector's restrictions. So the other supporting facts anyways are that the house was built in 1950, which meets the zoning bylaw 173-68 requirement that it be built before 1951. The outside appearance is not going to change at all. And a special permit was actually granted for this before I bought the house. I didn't know about that, or I would have acted on it.
Okay, board members have any questions?
I do. Melissa?
I have a question. On your diagram, is the second floor part of apartment number 1 or apartment number 2?
It is apartment 1. So,
Okay, so you label it apartment, that makes sense to me, but it didn't.
boy, I screwed that up, didn't I?
Yeah, because otherwise apartment 1 wouldn't have a bathroom or a...
Right. Yeah, I'm sorry. The
That's no problem.
whole second floor is
Okay.
apartment 1, and one whole side is apartment 1. So apartment 2 is just those 3 rooms
Okay.
on the first floor.
My only concern, Mr. Zagarella, is when you bought this property, they had gotten a special permit to state that, and I guess this is more a question for the chair. They'd gotten a special permit to state that it was a two-family and was granted a variance or a special permit to become a two-family. And evidently the building inspector required some alterations to have it conform to a two-family. I don't understand how something granted a special permit to be a two-family, then became not a two-family, and now needs a new special permit to become one.
Ms. Farnsworth, you can answer that.
I can answer that because I had a conversation with Mr. Bernier, and I also understand the process here. The special permit was granted. It was recorded with the registry of deeds, but a building permit was never taken. Therefore, the special permit was never, as the law says, enacted. So therefore, it expired 2 years later.
But when we grant a special permit on a grandfathered building,
No, you still have to file it with the registry of deeds.
The building codes for fire and access and
Yep.
egress.
I see.
And by
And
not taking
also,
the steps to
the
comply,
assessors
we didn't
involved.
act on it.
You know, because I just recently converted my house from a two-family to a one-family, and I had to go and get a building permit. Et cetera, the assessor had to come and, da-da-da-da, so it would be official.
Yep.
I guess my concern is, when you bought this, you believed it to be a two-family. Indeed, it was a two-family
It was,
when you
yeah.
bought it. It ceased to be so 2 years later. I would
No.
work.
No.
Yeah, I think it's still, is it still a two-family, or
Yeah.
you're still renting it? He's still renting it.
Well, I'm not renting it right now, but it's still a two-family, apartment still,
But he
still
can't sell
separate.
it legally and legitimately as a two-family because it doesn't have a two-family approval, certificate of occupancy from the building inspector. And the building inspector won't go out and see if he complies as a two-family without him having a renewed special permit, because the special permit lapsed.
Yeah, because the building inspector needs to issue a building permit such that then he can follow up with the certificate of occupancy.
Okay. My concern then is that this not happen to the next person who buys this property.
Right, it won't.
As a real estate broker, I don't want this
Right.
to happen to someone else.
Right, well,
So I guess I
they're
want to
gonna
make
know-
sure
They're
that
gonna
this.
know what's going on. I mean, the other people hid it from me, It's too late for me to do
That's why
anything,
you see
or I
it.
would,
You know,
I would
obviously,
be
they
going
get it from the
after
building
them, but.
department, so therefore the building department is not aware of the violations of the zoning bylaw.
That's why he's here. Okay.
Want to read Roland's
Yes,
statement?
I will read the building inspector's, but is there anybody here in the room who would like to speak to this application? For or against? Speak now, okay. 123 King Street, applicant is seeking a special permit to convert a single-family dwelling into a two-family dwelling pursuant to section 17368. The previous owner of the structure petitioned the Board of Appeals and received a special permit to convert the structure into a two-family dwelling in 1999, but did not exercise their right through a building permit within the required 2-year period. As such, the special permit lapsed and is no longer valid. No further comment. I'll entertain a motion to close the hearing.
Motion to close?
Second,
Second?
any discussion? Who was the second, John?
Yes.
No discussion, I'll entertain a motion on the petition.
Madam Chair, make a motion that we grant a special permit under section 17365 conversion of buildings to 123 King Street.
Second?
Second. Should we say anything in there about essentially reinstating the original special?
That'll be in the findings. That's just all part of the findings that leads to the decision.
We're not really reinstating it, we're giving it a
No,
special
but
permit.
you're kind of, in a way, you are. Not exactly, but you
Yeah,
are.
No, he's
that-
entitled, as a matter of, if there never was a first special permit, he's entitled to get one, he's converting a dwelling prior to 1951. So it'll be in the discussion and the findings, as Bill says, but there's no reason for the decision to reference it. We are at a second. All those in favor signify by saying aye.
Aye.
Opposed? None. 5 ayes. You can grant your special permit.
Thanks.
You eject some here?
Well, that one took about less than 15 minutes.
It took
Count.
10. It took 10.
Sitting traffic every morning outside the building, go dropping kids off at the high school.
Okay, we're at 8:10, and we are calling the 8 o'clock hearing on case number 839A, 8 Blood Road, the case of Joseph Royal, for a special permit or a variance from section 17310B1 for a proposed addition. Mr. Royal, I don't know if you weren't, some of you weren't in the room when we opened. What we do is we have the applicant present first, then the board members will ask questions, and then we'll read into the record any letters that we've received, and take any information from any abutters. And then, Mr. Royal, you'll have a chance to speak some more, then we'll close the hearing and vote.
Okay, thank you. So I'm applying for a special permit. The house is on a non-conforming lot. It's less than 4,000 square feet and has less than 150 feet of frontage. And I'd like to put in a garage with a room above. The garage is going to be 18 by 38 feet. And the bedroom above, not the bedroom, the room above, the family room above would be 18 by 30 and a half. The garage is going to bring us within 4.5 feet at its closest point to the property line. And then the front of the garage is going to be 7.5 feet from the property line.
That's an attached garage, so your room is going to be bonus from access from the second floor.
That's correct.
And what's your distance to the property line now before the garage?
I have that on the original.
It says 22.6, the shortest corner.
Yeah, so it's 18 and 4.5.
And how close is the house on that side of your property?
So it's 18 plus, 22 and a half.
Matheson is your butter on this side, right?
That's
Is there a
correct.
house over there?
It is, but it's vacant.
And how far from the property line is that house?
I don't know.
It's a,
I can't see it.
it's a bit of a, you can see it through the woods, but it is a bit of a distance. Roland says it's a vacant lot. Is there a vacant lot between that house and,
There's a house on it, but nobody lives there.
oh, it's an abandoned house, or?
Yeah.
Have you explored options of putting the garage somewhere else, like up front, or 4.5 feet is very tight for a garage? We were out there tonight looking at it. We got out my little trusty measuring tape and kind of tried to picture where your garage was. But it just seems very tight there. And you have a nice big lot. It seems like maybe up front or something. Have you explored other options?
The septic out front, so that's not really an option.
Isn't there-
Same thing on the other side of the house is you would have to drive over the septic to get to the garage.
Your proposed family room would come off of the second floor. Do you have a family room up there or I mean, sometimes houses on lakes aren't, first floor, kitchen, living room, dining room, second floor, bedrooms. Is that the situation with your house?
Yeah, that's right. The kitchen and dining area is on the second floor. That's where you would enter that bonus room.
And the bedrooms are downstairs?
There's 2 upstairs and 2 downstairs.
Any other board member questions?
Very similar to in the previous case. Here we have, again, a plan, or part of a plan, with no title, no date, or anything else. It's a septic plan with no definitive dimensions on it.
It's in the files, the whole plan. I'm sorry to interrupt you, but he submitted the whole plan. She only copied for the board the portion that she thought
All right.
needed.
All right?
So just,
And it does
Again-
have a scale on it.
Okay. Again, it's a septic plan, and the septic plans are only located in the septic system. They're not located in the house. It's penciled in here and saying that the distance is 22 foot 6 inches. That's scaled out. We don't know if it's true or not. And it's proposing to have the garage within 4.5 feet of the property line, which is really, really narrow. Which leads me to the question. The garage plan shows the garage at 18 feet wide. Standard garages are 12 feet wide. You got a 2-foot bump out there because I believe a fireplace, probably, or whatever else, would make it 14 feet, which would give you an additional 4 feet to the side property line, to give you a little bit of room to be able to get by the side of your house without trespassing, technically. Why, so the question is, why is this 18 feet wide rather than 14 feet wide?
So it's on a slab, so I have no basement. I was going to use that additional area as like a workshop or a workspace. to put some-
The garage is like 2 vehicles deep.
Yeah, that was the plan. That was the only way we can get a 2-vehicle.
How are you going to access this other bay?
They would be stacked in front of each other. So I would have to move.
So you wouldn't actually use the garage door in front of the lake?
No, to pull a boat through is how I would use it.
Okay.
And again, I don't know if you heard my discussions earlier with the dealing applicant. Now, as you're proposing, the side of the building would be 4 feet from the property line. I don't think you get windows on that side of the building, under the state building code. So I don't know if somebody was just a designer who drew these plans up, or somebody's actually looked at the building code or whatever else, but the code says if you're less than 5 feet, you've got a problem with anything on that side of the building. Windows, it's gonna be 5 or 8, but anyway, that's beside it.
Well, that's a good question. I just want to stop you for 1 second. Did you have a designer or an engineer or an architect draw these?
No.
So you've sketched this onto the septic plan, so.
That's correct.
Before you go further, you weren't here for the first discussion. There was a lot of angst about granting a 7-foot to the setback, and it was the same kind of thing. The fellow just wanted a deck, not a garage, and not a 2-car garage. It might make sense, in your instance, to continue this till the next hearing and go back and have this engineered or architecturally drawn, because I think the points are well taken, that if the back of your house is 22.6 feet to the lot line and you want an 18-foot garage, if you're off by a foot, you've lost any distance between the garage and the lot line effectively. It may be that you could move that whole garage forward and maybe knock a foot or two off of it and still have what you want and give this board what it sounds like they're gonna be looking for, which is more than a 4-foot setback. The other one had spent the money already for an architect and had what he believed were architectural drawings, which is why I just interrupted
And
you.
it was a deck, not
And it was a
two-story
deck,
building.
not a two-story building, and not living space, and not, effectively not a permanent structure. Even though, as the code defines it, a deck is a structure, I understand, but it's not, it's different. I would ask you if you would like to let us continue this, because one risk is that if you get a negative finding from this board, you can't come back for 2 years. And I don't want that to happen to you on a set of plans that aren't accurate. Not to say we wouldn't be sympathetic if the architect comes back and says there's no other place to put it, and this is the way the traffic flow has to be and everything, that makes sense.
But look at your width also. When you're down to 4 feet between you and the property line, then it's hard to get lawnmowers, maintain property without having to go on the other people's property. And that's always been a concern for this board, is how people can maintain their property and not have to go on other people's property to do it. So please look at the width, see if there's somewhere else that you could put your workshop or something that would be not quite so egregious.
Up to you. If you can go forward, you're here, and you paid, you can go forward.
No, I think continuance makes sense.
I think a continuance makes sense too. And I'm looking at it, and I'm not, these are the builders on this side of the room, but just looking at it, I can see a couple of alternatives that would compromise the setback and give you what you want, longer. It's gonna be tandem anyway, why not longer instead of wider, kind of thing. Yeah, Mark?
We're sort of giving him guidance, but being imprecise about it. What happens if he comes back and, oh, now it's 6 feet from the line?
That's a
Would the
good,
board
that's a
allow-
good point. Why don't you,
I'm just wondering, I would hate for him to come back and say, okay, I took 2 feet off, and then the board still votes it down. I'm not saying the board should make a decision now as to what's allowed, but it's kind of
We're not
fuzzy.
supposed to design, but
Yeah.
it'd be nice if he pulled it forward a little bit. He already has it as far forward as his porch at the.
But he can't do it without
Right.
asking some kind of variance. He's gonna be within the
Yeah, he's
setback,
got-
so it's a
yeah,
matter
it'll
of
be within the setback.
what would the board tolerate?
In New England, all God's children should have garages if they can.
Well, that's
And
true.
decks.
And
I
decks.
wouldn't buy a house without one.
Yeah, so, we
yeah.
we understand the need for a garage, so, but if, there's gotta be a way to get it more than 4 feet. We just granted something that had 7 feet with heartburn, so maybe keep that in mind. Maybe you can't be 7 feet, maybe you can be 6 feet, and maybe we can live with that. So, but see what you can do for us, and to get us a little bit more
Well,
space.
For the zoning bylaw, because don't forget, if you do this, your neighbor can do this, and then all of a sudden, we've got 2 houses 3 feet apart, and that's not fair to the whole neighborhood.
And keep in mind Bill's comments about building codes, and if you're within 5 feet of your, I don't understand I don't know the building codes well enough, but Bill does. And he says that you would not be allowed to put windows there if you're less than 5 feet away from the property line. He's probably right. So you might want to keep all those things in mind.
Another strong point, that whether you're asking for a special permit or encroachment into a non-conformity or a variance, whatever else, it always comes down to is that you look at other alternatives, and that this is the one that fits your need. It's want versus need. You know what everybody wants, but it is what your need is and what fits your needs. So you have to demonstrate to the board that you look at a lot of other alternatives, such as making the garage only 14 feet wide with a 2-foot bump out versus 18 feet wide. You know, it give you that extra couple of feet, whatever it is, to the property line, as well as the accurate dimensioning of where that building is. And again, I've seen them anywhere from 5 to 10 feet off. You may have 30-something feet there, or you may get 10 feet there. So that's something we need to know before we can make a definitive decision.
And I'm not going to get that unless I have a certified plot plan.
Well, it's not a certified plot plan either that you need. You really need an engineered lot line on that side of the house. It's just shooting one line.
Yep.
But a certified plot plan will not satisfy the board, or you, because a certified plot plan is just somebody going out there and
Eyeballing it.
well, it's more than eyeballing it. They look at the plan at the registry of deeds, and they go out to the land and they try to tie it into something, but it's not accurate. You need the line shown.
Let me comment. I've dealt with this question for 30 years. I was a building inspector, zoning officer. Worked with a lot of engineers on very similar situations, a lot of people. Because I always insist that we had in our bylaw, you had to actually have that before you get a building permit. Talking to many surveyors and surveying companies, it can be as cheap as a couple $100 or expensive as a couple $1,000 or whatever else, depending on who the surveyor is or the engineering company and whether they want to charge a flat fee. But if you just have them go out to a building that's already established and a lot line is already established, they can do that for you, very minimum fee. It's not that expensive if you go and you contact the right people. You may have to call or check with 4 or 5 different companies. Don't just take the first one you can go to, all right? But it can be very, not as expensive as people think it is.
Okay, because I did get an estimate for $1,200 to $2,000.
It should not be, I mean, you should be able to get, just, all you, and the thing is, when you go to the surveyor or the engineering company, whatever, ask them specifically, can you just give me the dimension from the edge of my house to my property line? If you go and say, I need a certified plot plan, they're gonna think big. They need to do 2 days of work. You ask them for one very specific, the price comes down and it gets a lot simpler.
I am going to read the comment from the building inspector so that you have the benefit of that. 8 Blood Road, applicant is seeking a special permit to allow encroachment into the required side yard setback with an attached 2-story garage family room addition. Although the lot is legally pre-existing non-conforming, the structure is conforming as it meets the current setbacks required by the Littleton zoning bylaw. The addition of a garage to the right of the existing structure is creating a new nonconformity, not intensifying an existing nonconformity. That's the basis for a special permit. I believe the applicant should be requesting a variance. The vacant lot to the right has no bearing on this issue. No further comment. So, with the building inspector's guidance that this should be a variance, not a special permit, this requirements, the criteria to satisfy the board for a special for a variance are higher. There's a higher standard you have to meet. And as I think Jeff said, or John said, this side of the room said, it's not a question of what you want, it's a question of what you need on a variance. You have to establish the hardship, and you have to establish that there's no other way to accomplish what you need, not what you want. So again, all the more reason why you need this surveyed line from the house to the lot line, so we can see exactly what the distance is that's there. Make sure you can get around it, as Cheryl suggests, to mow, to get to your backyard, to get to the doors, to get your boat in and out, and be carrying a can of gas at the same time. and still respecting the zoning bylaw and the neighbors. So, as Mark pointed out, this board is very generous in granting our special permits and our variances, but we're very cautious to make sure that the abutters and the intent and purpose of the zoning bylaw is still preserved. Okay.
One quick comment. In regards to Roland's comments and everything else, I had a conversation with Roland about all these cases and everything else. He's reflecting back again to the Diedrich case. He has not seen the full details either. He just knows that a council had made a comment in regards to that case. But this board actually needs to be definitive and give guidance to Roland as to how we're going to deal with such cases, whether we're going to continue with a special permit or a variance. So that's where Roland's comment is now coming from.
Yeah.
But it's not definitive until we have a chance to check the legal cases.
We'll have that case reviewed and answered by the next meeting as well. Patrick?
How are you gonna get that second car in the garage? Is it one after another?
Yes. Yep. And so when the first car has to get out, the second car is going to go out first.
You have to like each other.
And the front bay is, because he's got a boat, and he's right on the water there, so the front bay makes sense, so he can pull a boat through. But he's not going to be able to pull the boat around anymore.
Yeah.
He's going to have to pull it through the garage.
7:30?
I just didn't ask if there were any abutters who had any interest in this petition and want to speak to it. Okay, I'll take a motion to continue.
7:30,
When's our next meeting?
October 16th. It's almost every week, but
October 16th at 7:30 PM. Is the motion to continue. Can you be back at that time? Okay, go ahead.
make a motion we continue case number 839A for 8 Bud Road to October 16th at 2014 at 7:30 PM.
Before you vote, would it be useful to get some information on the lot?
Provided that we get the information that we've already talked about and requested at least
We
1 week
can't put
prior.
provisions on coming back on the continuance.
No, I'm just wondering if we could request.
Request
some
it, not-
detail for
not
the lot
conditions,
next
but
door.
request.
And that house, how far back it is, that kind of thing.
Can we stipulate, Madam Chair, that we do not get a 1 week prior, that we will be forced to either make a decision, lack of information, or continue? I've requested-
No, I'd rather you did,
requested
because
this
he's
many
at the
times.
mercy of the surveyor's schedule, and we're not gonna push people month to month over that. If we're requesting you try to get the information 1 week in advance. If for any reason there are complications or surveyor delays and you get it 2 days in advance, the board will likely suffer suffer with having to review it the night of the hearing, but we would like it a week in advance if we could. Okay. We have a motion, I didn't hear a second. To the motion to continue.
Second it. I was waiting for Jeff to take a turn, for God's sake.
I seconded the last, sure.
Cheryl? Okay, all those in favor signify by saying aye.
Aye.
Opposed? Hearing none. Thank you, Mr. Rick. Okay. It's now 8:27 or 8 PM, and I'm calling the 8:15 case, number 840A, 271 Goldsmith Street, the case of Joseph Kudrow for a special permit or variance from section 17310B1 for a proposed addition at 271 Goldsmith Street. Mr. and
No,
Mrs.
Madam Chair,
Yes.
with great sorrow, I have to recuse myself from this hearing. I have had the applicant's house for sale in the past year, and therefore have to leave the room.
Okay. We'll miss you.
I'll miss you.
I have 4 alternates, and I was not present for a couple of hearings. I had to recuse myself, so I don't know which alternates have been overused and which ones have been underutilized. So who hasn't had a turn in a while would like to sit on this?
Mr. Joyce went and saw the property.
Mark hasn't. Okay,
Well, I
Mark,
did
you're
the
it.
last meeting,
Oh, you're it.
but we're-
Okay. Mark Saucier is appointed the voting alternate. Okay, present as informally as you like, please.
As Cheryl stated, we tried to sell our house. I bought it when I was 22. It's a one-bedroom ranch-style home. When you buy a house at 22, you think you're gonna be 22 forever. And it didn't work out for me that way. Since then, I've gotten married. We've been married for almost 3 years now. We've tried to sell the house on a couple different occasions. We've put a lot of work into it. Unfortunately, it didn't sell. It's hard to sell a one-bedroom house. So we'd like to put a very modest addition on a very modest home. The house as it sits, it's a little over 700 square feet. I'd like to add merely 300 square feet. That would give us exactly what we need. The way that I understand it is the house is too close to the road now. It's governed by the code. So we've set the addition as far back as we can without interfering with the septic. That's about where we stand.
So the size of your addition?
It's approximately 300 square feet, man.
Yeah, so do you have the
Sure.
the dimensions?
Why don't we go to have it entered with the
Gotta be into the record. On the tape, remember? Okay, so the contractor has listed the existing nonconformities 10,454 square feet of lot size, 86 feet of frontage, front setback is 25 feet. The dwelling meets required side and rear setbacks. The addition is proposed to be 27 feet from the front property line, as opposed to the current 25, so they are setting it back. The side setback will still conform, and the rear setback will still conform. So he's really not increasing any, well, he is making more front non-conforming.
Actually, the existing house is non-conforming.
Yep.
As soon as they add onto that, that's increasing the non-conformity.
Yep.
Per the Gale case.
Yep.
But
So,
it's not creating any new
not
non-conformities.
creating any new ones, just
Correct.
increasing the existing. Correct. Okay. Single story.
Yes, ma'am.
The contractor is a well-known, reputable contractor as well. Anybody here that abuts 271 Goldsmith or is interested in this application that would like to speak to it? Yes, sir, please.
No.
No?
I don't want to speak, but no, I agree they can build.
And can you identify yourself for the record?
David Palsy, 13 Evergreen,
Do you back up to him?
on the very back corner,
Spell your last name, please.
Polsey. I know the house quite well. Previous owners are good friends of ours, and it is a very small house.
Thank you. Okay, you want to read it?
David from Roland Bernier, zoning officer, September 16, 2014, 271 Goldsmith Street. Applicant is seeking a special permit, section 173-B10-1, to allow encroachment into the required front yard setback with an attached one-story bedroom bathroom addition. Existing house is legally pre-existing non-conforming, in that it presently has less than the required 30 feet from the street property line. The one-story addition is intensifying this non-conformity. No further comment.
Any other comments?
Yeah.
Yes.
Yes, I mean, great, we have a plan we can work with. This makes it really easy because you do have a plot plan that tells us exactly where the house is located, what the dimensions are, what is non-conforming, what is conforming, and what you're trying to do, along with the plans. I don't know if you heard the previous discussions, we always look at and saying, are you asking for way too much and a little more than realistic? Based on what's here, it looks very realistic within, normal sizes of rooms in normal living spaces. So overall, the presentation and the information submitted makes this case a lot easier to deal with and a lot easier to decide.
He just gave you an A+.
Oh, yes, what's in the instructions?
Yes, it is. Yes, it is.
Now, is this staying as a one-bedroom?
Yes, sir.
You're just making a bigger bedroom?
No, it's a two-bedroom.
No, we're going into the existing bedroom with a closet from the new bedroom, so it won't even be another bedroom.
We're gonna turn our existing bedroom into an office. She does a
Yeah.
lot of work out of the house. We'll make a bigger bedroom from us, and we're extending the living room by about 6 feet or so.
Oh, and then you don't have to sell and we can keep doing it.
Yes, ma'am.
Exactly,
That's
that's the plan.
Are you service?
No, ma'am.
Oh, you sound like you were in service. I'll entertain a motion to close.
Motion to close?
Second.
Oh, I hardly ever get a chance to say.
Go ahead. Go ahead.
Made him a voting member, let's get him started.
I know, what do you think?
Want to make the motion?
I make a motion that we grant the special permit to allow a single-story addition per drawing, site plan, no number, A1,
They submitted with the application.
as submitted with the application.
With date.
Oh, dated, yeah, it is dated July 18, 2014.
And floor plans? or architectural plans. Yeah, reference the.
Oh, and, yeah, reference
the
the,
date.
also attached, foundation and floor plans, A2 and A3.
Special permit to the address.
Special permits, tell I do this a lot. Special permit to the address of 271 Goldsmith Street.
Done yet?
Second?
Second is Bill Farnsworth. All those in favor signify by saying aye.
Aye.
Opposed? Congratulations.
Thank you.
Now, I don't know, but you're talking to Roland, you explained this, it's a special permit, so now you can have the 5 building permit now.
Okay,
And he can issue it prior to the 20-day appeal period after the decision has been filed. But you still do that at your risk, but at least get your building permit process going, and have it ready.
All right, well, thank you very much. Good luck.
You're welcome. Good luck.
One question, my name was spelled wrong on the
Just on the agenda?
Just on the agenda that was emailed to me.
That's fine, the agenda is fine, as long as your name was right on it.
Spelled properly.
That's what we go by.
Thank you. No, thank you for correcting.
Thank you very much.
Don't tell anybody else.
Transpose the letters. Well, Cheryl, it's only 8:40, I think we should make the next one wait till morning.
We move fast, you gotta admit.
No, we move fast tonight, but I usually try to
Yeah,
start with 15
yeah,
minutes.
yeah.
That's one way we get.
I'm gonna be asleep on the car.
Okay.
1 minute manager here.
Okay.
I'm gonna wait till 8:40.
That one was fast.
That one was fast. They were-
Because we get good.
They gave good information. That's right. This one is 8:30, just give me 1 minute to catch up.
If you need to, we'll get it. You know, this is where you go.
Well, she's read, it's being taped, so Shelley can watch it and get the minutes. I just put some notes about who was fighting the phone, I guess you can't.
No.
The voices. Okay, the time is 8:40 PM. We have an 8:30 PM discussion on case number 795B. Request for modification of comprehensive permit at Wildflower Meadows, 15 Great Road, non-substantial change. And I think you guys have a lot of bravery coming back to us so soon.
You want chocolate?
No, thank you. Thank you. No, I'm hyper enough as it is. Thank you.
Introduce yourselves and.
Absolutely. My name is Mark Gallagher, and this is my son, whose also name is Mark. And we purchased the Wildflower Meadows project from 15 Great Road LLC. We probably remember us as the consultant for the for sale part of the project as it went through its permitting process. And we acquired the property at the end of July. I believe it was July 30th. And we've got off to a nice start. Project is coming along very, very well. Some things that we realize now, obviously, that we may not have realized then is that we, at the bottom of our market, we're not seeing sales that we designed units around. At the top of the market, we're not seeing sales that we designed units around. It's not unusual to, with the number of units that we proposed, to have some that are popular and some that are not as popular as we thought. And we would like to ask two things this evening other than introducing ourselves. The first would be, we'd like to show you some changes that we're proposing to make in the second phase, which is the last 32 units that are going to be constructed, which would be constructed over the winter and into next year. And then we would like to come back possibly and talk theoretically about some changes to the array of units that we proposed and have approved by both you and our subsidizing agency for the market rate units, so that we can meet some needs of people that have come and visited with us at the property that haven't purchased but would be interested in purchasing in Littleton, if we can make some changes to some of the plans that we've already had approved through you and also through the subsidizing agency. So before we came this evening, we did speak to the subsidizing agency, as we did during the vetting process, and really their focus isn't on the market rate units, their focus is on the subsidized units. So the affordable units, we do have affordables under construction now. We anticipate that based upon the lottery and financing, that we will probably be conveying the first lottery unit sometime before the end of this year. We expect to be conveying our first market rate units when the treatment plant is up and going, which will probably be sometime the end of October or the middle of November. So one of the things that we've also run into in the field that we didn't anticipate is we have a great deal of ledge. So I think during the permitting process, if you remember back, we had plans with building envelopes, and we had some flexibility on moving those, which we are going to have to do in some instances in order to be able to slide from the ledge. One of the things, or two things that I think you'll be very happy of, specifically you, Cheryl, after your comment earlier this evening about garages, is that all of the units at Wildflower will have full basements, including all of the affordables. We decided to blast all the ledge. There were impediments so that we would get full basements in every unit. And we also have garages attached to every building now.
That's a wonderful thing.
Yeah, yeah. So every unit has an attached garage, and every unit has a full basement. So those are probably two elements that we had talked about during the permitting phase that I know that you were all strong about, but you were very willing to work with us to allow us to have slab-on grades or to have less than full basements. And we made the decision to go with full basements for the entire property. Okay. So I have some handouts for you. Yes, I'm sorry.
I'm sorry.
I apologize, sure.
I apologize. Sorry. We would like for you to begin with a formal transfer of ownership notice. It's clear that the decision allowed this to happen, but I said that the board would like very much to know when things like this happen, because we're all the ones accosted on the street. So you've introduced yourself, but will you tell us now the entity that will be...
Oh, I'm sorry, yeah. The name of the company that we formed, as you know, under the law, we have to form a separate entity because it's fully audited, and it's a limited dividend company. The name of the limited dividend company is Wildflower Village LLC. And that's the one that took title to the property.
And you took property, title to the entire property, including the apartment building?
No, the apartment buildings are all still held by 15 Great Road LLC.
That's what
I believe it's held by 15 Great Road LLC 2.
Mark, can you raise that up onto a board so we can...
Yeah, absolutely. Let me hand these out, if I could.
There were 3 phases in the decision. If you put it right on the window ledge, it usually, we can all see it from there usually.
Just to refresh your memory, this is the approved plans. And I made small copies so you could follow along this evening, as well as having...
Just go a little further and lean it right against the wall, right? Put it right on the window ledge, but lean it against the wall. There you go.
Mr. Joyce?
Everything.
Your chocolate. Here, take a plan too.
Now, show them phase 1 and how the decision has been approved. Thank you. Thank you.
So what I've given this evening is you have now the one that is approved, but that you approved originally to demonstrate. And then there are, what I've broken it out as, I've broken out into 2 additional copies, not to be confusing. One which is overall just to this project, and then one in phase 1 and one in phase 2 of just the for sale. So let me take you through what was originally approved, and then we can show you what we propose as we break it down. Yep. So if you'll remember back so many months ago, yes, Sharon?
No, I said phase 1 and 2, it's lot 1 and 2 is the way.
It is, yeah, we designated as phase 1 and 2.
Yeah.
There were 3 elements of the property, if you remember the permitting process. There was lot 1, which is out along Great Road. There's the Boxwood Drive that continues all the way through to the subdivision. There was what we call lot 2. Lot 1 had 24 single units on it. Lot 2 has 32, 25% of which are affordable in both lot 1 and lot 2. And then there were the 144 apartments that I believe are on lot number 3. The apartment complex also has the amenities, which is the clubhouse, the pool, and the play area. Okay, so initially, when we received our approvals, one of the concepts we talked about in Lot 1 was the loop, which was Morning Glory Circle, with 6 units inside of it, facing the opposite way, so they faced into the property. And then there was 6 individual garages that were along the face of Great Road.
Right.
So in terms of the ledge, the impediments that we talked about, this side of the road is all sand and gravel. From Boxwood Drive, as we go all the way back, till about here was a ribbon of ledge, and it was very, very significant. So we have blasted the center section. As we go down through the rear of the property, you'll recall that there were units that were stacked along Boxwood Drive that look at the apartment buildings. There were 2 spur roads that came up, and off the spur roads, there are about a half a dozen to 8 units coming up off of it, and then there are 4 units that were originally approved along this side of the property. It's up against the conservation land. Any questions that I can help as we go along?
We understand what was.
This is what was.
Right, we understand what was.
Okay. So,
There's more of what will be.
absolutely. Let me show you this plan, which I've provided you in your handout. So as we look at what is Lot 1,
So, we need to pass them on down. Here's the one I'm talking about. And then you can take one of those. Pass those down. Pass those, and then you can take one of these. Pass those down. With my salary.
This is a back end.
It's back in. So you should, everyone should have 4 of these.
correct. What was,
What
as an
was?
entire project,
Yeah.
what we're generally proposing for the entire project being Lot 1 and Lot 2. And then you should have a 3rd sheet, which is just Lot 1 and just Lot 2. So they're blown up a little larger as we go through. So on Lot 1, on Morning Glory Circle, as we encounter the ledge, what we have done is we're widening the distances between Morning Glory Circle itself a little bit, eliminating the garage that apparently nobody really liked along 119 to begin with, and we've incorporated garages into all of the units that are inside Morning Glory Circle itself.
That looks like a wonderful change.
Thank you. That's the only change that we are proposing, and we wanted to make you aware of as we move
Can
forward.
you point out to us which in Morning Glory Circle are the designated?
10 and 12, which would be the top of the top right-hand corner
Right.
and the bottom right-hand corner are the 2 affordables I'm assuming that you were going to ask.
Okay, and are the size of them?
The size actually got larger because we have a garage, and with an attached garage, we have a bonus room over the garage for all of the units. So we've actually enhanced all the buildings with the attached garages as opposed to the detached. Any other questions for the first? No? Okay. So in the second phase, what we're proposing to do is along Boxwood Drive. What we would like to do is we'd like to get away from all of the buildings along Boxwood Drive being tight, close together, and be able to spread them out so that we can get some side loads for the garages as well as front loads. We felt that the ribbon of units along Boxwood, all with garages facing the road and with walls facing the road, wouldn't be that aesthetically pleasing now that we are, building the buildings, if you will, into the existing topography. And so what we propose is spreading them out a little bit, and we've wrapped 2 more units up along Buttercup. One of the things that you had asked for during the permitting process, we consider obviously anything that's up on the top of the hill to be premium. You had asked for 1 unit to be up there as a minimum. Now we're driving a second affordable unit up onto the top as well.
Is that 32?
I'm not as familiar in Phase 2 with the units, to be very honest with you. But I know that up here you asked for a Rosebud, so that it could be, a Rosebud has a bedroom on the 1st floor as one of ours, and you were concerned about handicap access possibly. So I know that we acquiesced to putting one up there during the permitting process. One of the pestos has slid all the way up, which isn't affordable, so it's up on the top now as well. So what we're trying to do is spread them out a little bit, you know, if you will, to get some distance between them as you go along Boxwood, as opposed to them being 15 feet apart. To be able to get some side loads to get the garages off the face of the buildings. And what we'd like to do is to come back next month and talk about being able to meet some of our targets in terms of, you know, with the side loads is possibly getting a master bedroom on the first floor and second floor. We've had a lot of requests for that. Our plans didn't envision that as a request from the get-go. It's a big request for people our age that are not quite ready to go to one level living, so they would like to be able to have the flexibility of a master on the second floor now, while they can still make the stairs, use the first floor as a guest or for children, and then rotate down to the first floor, 10 years from now, or when it becomes necessary that one of them or both of them don't want to make the stairs any longer. So that's probably a target market we kind of missed. The other target market that we kind of missed is initially, if you'll recall, one of Ed's concerns were size, that there weren't units in the upper range, if you will. So we had originally proposed that we had units that were above 2,300 square feet, a half dozen of them. And during the permitting process, he convinced us that there really wasn't a market for that, so we eliminated that plan. That plan actually, we've not shown it, but we've got, folks, again, that are our age that are interested in moving, as an example, from Acton or Boxborough to Littleton, and they would like to have something a little bit bigger than 2,300 square feet. And, we really can't meet that need. Peter's project is got much larger units on it. And, these are, again, people our age that...
Tell the board who Peter is.
Sorry?
Tell the board.
I'm sorry, Peter DeCarolis bought the property that's out back, the single families.
Thank you.
And they're in the 26 to 4,000 square foot range. So, I think he's kind of shied away from the 2,600 and gone a little larger now. So there's a gap in there that people are coming to our property and saying they would like to see, to move to Littleton. And again, we don't have a product that really meets it. So we'd like to be able to introduce some of those. Originally, we had them along here, and we removed them, and we'd like to reintroduce that, that style so that we can, in the market. In the end, we get audited, as you know, and we're under the guidelines of MFHA in terms of profitability. When you hit all kinds of, the kind of ledge that we've hit, it's a significant amount of dollars being spent every day to kind of get those full foundations. So we'd like to be able to have 3 or 4 of those units back along there that we can be a little bit more profitable because of their size on, and therefore make up for some of that ledge that we are putting full foundations in under all the units.
So I just lost you in the last few sentences.
Sure.
You've got 3 eliminated units down under here.
No, we didn't eliminate them, we just didn't do the building envelopes yet, because we
Okay.
didn't, again, we want to make
those.
those a little larger, so we had 4 along here, we wanted to go to 3 so we could make the buildings a little larger. We've spread these all out, Sherry,
Got that.
and tucked units up along to spread it out and give it a better streetscape as you go along. I mean, we've had a lot of folks, I don't know if any of you have had a chance to come out to the property, we've had a lot of folks come out, and we've only got 2 houses under frame right now, and we've got 3 more starting next week. But people are very warmly surprised at the architecture, that they really like the way that the streetscape's starting to develop, so we'd like to continue that.
How many units in this lot 2?
Lot 2's 32.
And how many affordables in there?
There are 8, 25%.
And how many would you propose to increase in size?
We want, of the 32, we're proposing to increase in size 3 to 4.
In other words, he wants to put some nice, really nice big ones down here.
Correct.
And I don't have a problem with that. I am wondering, when your first affordable unit will be ready before the end of the year, you're saying?
Correct. 6 is under construction right now, right here. We'll actually, well, depending on the lottery and how the lottery will be
When will the lottery
fulfilled.
be opening?
It's starting.
Is it?
The outreach has already begun. We hired Mary Lynn Owens out of Lexington. She's one of the lottery agents that's approved by MFHA that they like to work with. And we hired the Chelmsford Housing Authority as our marketing agency. And they've already begun their outreach. There could be more than one before the end of the year. It really depends on how quickly people can get financed. We've had a lot of interest.
It'll go up to Shelley the minute you have it.
I'm sorry?
It'll go up to Shelley the minute you have it, right?
Shelley already has it.
We've submitted the permits for 1/6.
No, I'm sorry, I mean
No,
the
no,
water
the outreach part.
application.
Oh, I'm sorry, my
Yeah.
apologies.
Yeah, the outreach part is already gone. Let me think. Last Wednesday, I think, Lisa Singleton, the Chelmsford Housing Authority, returned from vacation last Wednesday. That was the earliest that she could start to review and approve. And I believe that we got notice Friday that they were beginning their outreach. We've had I'm going to say quite a few, maybe 8 to 10 folks that have come to open houses and shown interest in the affordable units. So we're hoping that, the first phase of 6 would be oversubscribed.
You might
which
do,
would be wonderful.
Oh, good.
Yeah.
You might, both Ms. Gould and I have,
I'm sorry?
both Sherry and I are aware of a couple of families
Right, that need-
that
yeah.
are in need of the,
Absolutely.
that fit the parameters of low-income housing.
It would be wonderful. We would like to obviously, originally, as you know, we proposed that they could have the choice of units. Now we're at the stage where we have to build a unit, so we're hoping that they can make the choices inside the building that they would like to have, for the decor. I think that everybody finds it very exciting that a new home is being
Are
constructed,
there
so.
can I just ask a quick question? In phase 1, are there any of the affordable units have masters on the first floor?
Yes, they do. Yes, they do. Yep. The most popular unit right now is our Foxglove, which is like a 3-bedroom, second floor, like a small Garrison colonial. For the market, that's been our most popular unit. And it also is one that in terms of affordability, is ones that you selected for one of, or two of the first 6 units in the first phase. So,
Well, it makes sense.
yeah,
Because quite frankly, the population, there is a strong population in this area, folks that don't want to worry about mowing yards, like the condominium, landscape options, and worry about painting the house or in exterior maintenance so much as they need to, and yet want a good-sized house.
right,
So
yeah.
it all seems positive to me.
So you're formally here for,
Formally here for you to approve the insubstantial changes to the engineering plan to allow us to move forward with the movement of the buildings on the property as we've proposed.
and you told me that your envelopes, your building envelope sizes will remain the same,
Correct.
and that the even expanded size with the garages still fit within the envelope we approved.
They do.
And at this point, we're only talking phase 1.
We're proposing phase 1, the changes in phase 2 are along here where we're blasting now. So we need to get your consent because we're putting in sewer and water tees into areas that we don't want to have to move them again because we're in significant amounts of
But where
lead.
you haven't,
I'm not asking for changes to the buildings at this point, the actual,
Yes,
I'm going to come back,
changes to
what I'd like to
location.
do is come back next month. The architect, although the engineer moves quite quickly, the architect wants to be a little bit more pensive about the designs, so I couldn't quite get her to jump through
That's fine,
my hoop as quickly as I wanted to.
that's fine. So you're just asking for a location change tonight?
Correct, I'm just asking for the
Building
flexibility to
location
move the buildings.
Sure.
Yes.
That's a question. I just want to be clear, number 32 and number 34 in this phase 2, seems like those are the only 2 units that you're showing without a deck?
Every unit gets a deck.
Okay, so.
Every unit in the property gets an 8x10 deck by default,
But
including
just
all
not
the
shown on the.
affordable. Correct.
Yes.
Correct.
And each one of those will also have garage too, is everything?
Everything has a garage and everything has, it either has an attached garage or it has an undercar garage. And they're equally distributed throughout the property in the second phase, based upon topography. So the mixture of market rate and affordables for undercar garages are the same as they,
a personal piece of advice here
yes, ma'am.
from experience, if you can attach the garages rather than put them under, you'll find that you'll have much stronger market of people you're looking at. They don't want to have to carry their groceries. People who don't want to have to maintain yards also don't want to carry their groceries up the stairs from their garage.
We know that. And unfortunately, this entire front, actually 1, 2, 3, 4, 5, and these 4, they're forced to be undercar garages. The topography on the property it's,
The ledge is extremely tough, much tougher than we
You
expected.
might look into an option of a lift then.
Yes.
For groceries, you know,
Yep.
one of the small lifts that can take a sewing machine, groceries.
Okay.
and different things on the second floor. Absolutely.
Any other comments? Board, entertain a motion.
Do I read Roland's statement?
Oh,
Because if there's a-
Yeah, go ahead and read it. Sorry, I already closed mine.
Comment from the Roland Bernier zoning officer dated September 16, 2014, Wallflower Village. This office has no objection to the transfer of ownership or amendments as proposed.
So formally, we'll vote to approve the transfer of ownership, even though that is left to your subsidizing agency, but we'll just do it here, so it's.
Do we have the specific paperwork or anything that gives us that information?
That was turned in July, 2 weeks before the closing. We provided it to town council.
But anything provided to this board, so we do the transfer.
Yeah.
of
What?
Because who we're transferring to?
She didn't send it down.
We didn't get any information prior to this hearing. so.
No, it was sent in by letter,
Yeah.
by email, it just didn't come to us in the packages for some reason.
Again, it was not provided to board members prior to this hearing.
When did we get permission to break this up into separate ownerships?
That was part of the whole presentation.
Did
Well, we
everyone else
will not
understand
then vote your transfer of ownership, but we don't have the authority anyway. If the notice is in the file and it's been submitted to the subsidizing agency and town council, it's part of the record
We did.
that we need. And we do have the authority to vote first whether this is a substantial or non-substantial change, and then to vote to approve or not approve the change. So first I'll entertain a motion to determine that the changed locations as proposed do not constitute a substantial change.
And this can be done without being a hearing.
Yes, but it was posted. It is a hearing.
As a meeting, not a public hearing, right?
No, it's posted
It
as
is
hearing.
posted as a
Oh,
hearing.
because the agenda just says discussion of. So, okay, so I was just.
Yeah, it's okay.
What was the hearing number, the case number?
Wait a minute.
It's case number 795B.
Yeah, 795B.
I would make a motion that we consider the proposed changes to, I guess we refer to them as
Wildflower Meadow,
Wildflower Meadow, Part A and B,
Lot 1 and 2.
Lot 1 and 2, as insubstantial.
Second to that motion, please. Everyone second it? All in favor? Aye. Opposed? None. Next, take a motion to allow the change locations of house units along,
Be 7 through 12 on Lot 1. I'll put my glasses on for the rest of it. 32 through 40 on, 32 through 40 and 53 is Lot 2.
as shown on these plans from Places Associates dated Feb. 4, 2000.
Doesn't look like you really have changes on Lot 1 at all.
Yeah, no, just the elimination of the garage and the addition of the garages to the units. The units
Okay.
really haven't moved around.
Okay, so you're not really making changes to the locations of the houses on Lot 1, other than adding garages to the individual things and getting rid of the mass garage?
Right, which
Okay.
moves the units around in order to meet the
And
separation of the units.
Basically, you've taken one off of Boxwood Drive, if I'm counting correctly,
On the phase two,
on Phase 2. You've taken
Correct.
one off of Boxwood Drive and
put it on Chamomile.
put it on Chamomile.
Correct.
4 there, 1 there. Oh, I see, so there's 4 there instead of,
There's
on
3
the upper
instead.
right-hand corner, there's 3 on the original, there's 4 there now.
Correct.
Now, landscaping, are you getting any closer to the neighbors?
No. No. We're getting further away from the neighbors.
Okay? And we have a landscaping design.
You do.
Can we ask that you please maintain, for example, the landscaping design shows trees between all the different houses. Can you see what you can squeeze in? And
We
keep,
provide landscaping plans for each of our plot plans. We have individual plot plans that we provide to the building inspector before we get a building permit. That was part of the process that we agreed to when we initiated the permit.
okay.
So he
I guess
gets
I'm
it.
looking for reassurance.
Oh, yes, absolutely.
That there will continue to be
Yes.
landscaping, particularly behind the houses, and, well, you know, it's just not going to be, it's not going to be to their interest not to give the landscaping, because they're not going to be able to sell them as nicely. The landscaping is cheap as compared to other things.
Motion? Frame it referencing the revisions 918 of Places Associates Inc.
What are we're approving, we're approving the change, but do we have to do the insubstantial change
We did,
also?
we just voted that.
But this is not, okay, I'm just confused about
We
it.
have to say it's an insubstantial change, or then otherwise we have to reopen the whole case.
So this is also an insubstantial change.
The change of location is what we're talking about. They've asked us to
I
approve change of
understand,
location.
but
We just-
it would be approved as an insubstantial
We just
change.
voted that this would be
Oh,
deemed as
gotcha,
an
okay,
insubstantial
okay,
change.
okay.
So now we're on the motion
Yes.
to approve the
Okay.
change locations.
I move that we approve the changed locations on lot 1 and 2 as shown on the revised site plan dated 9/18/2014.
You want to specify specifically units 7 through 12 on lot 1 and 32 through 40 plus 53 on lot 2?
Yes.
Second, please.
Except for not at 9/18. 9/18 is, isn't that the,
Yes.
It's September 18th.
September 18th.
what's this, February 4th?
That's the original.
The original.
Oh, okay, got it. Sorry.
It's actually September
Who
18th.
seconded that?
I'll second.
Okay.
John?
Yeah.
All those in favor signify by saying aye.
Aye.
Opposed? Good luck.
Thank you.
Thank you.
Now, do you want chocolate?
Sorry? No, thank you. But thank you anyways. We'll see you next month.
I still have your attention. I got one more set of minutes.
You want us?
No, thank you.
Thank you. Do I owe you money? Am I all set, Jeffrey?
I don't.
We'll
I don't
take
have
any
a
money you
receipt for
have.
you. Yeah,
I'll take all your money.
I'm just sitting in for the treasurer today, so I don't.
Okay. If we owe him money, I'll take, feel free to give us a call, he'll come by.
I'll bring it. Thank you.
Thank you.
Thank you.
Thank you.
I'll just make a quick comment that if we did go to half-hour spacing for appointments, we'd still be waiting to start the last. We would be starting at 9:30.
All right, so I take
Just
it
mention
back.
this.
And usually they don't go this fast. Come on, we
No,
can't.
that's not true. You've just been spoiled by Bill. He likes to drag them out. I like to move them along.
Well, if we get the right information to begin with, we'd be able to.
Tonight we've gone even faster.
We get a set of instructions, let's follow the set of instructions.
Okay, May? Are we looking at May?
May 22.
That's the one I stood down for, I think. Did you too? No, I stood down. Did you do it? Go ahead.
Anyway, for 18 Washington Drive, he's referring to Michael Field, isn't it Matt Field?
They're brothers, and I don't know who presented.
I mean, I had my, I
think it
told him
was
my
Matt
folder,
Field.
and I keep writing down
No,
Matt.
Matt wasn't here, it was
I think it
Michael.
was Michael.
It was Michael.
It was definitely Michael,
It
yeah.
was Michael.
We all know Matt.
Well, it should refer to, other than petitioner owner Michael Field appeared before the board, period. After that, every time it says Michael, it should be Mr. Field presented. I mean, we had a precedent, we set a procedure before, and everywhere in here it refers to Cheryl, it should be the publisher, and the place it refers to anybody by first name, it should be no Rod, it should be Mr. Stewart. I mean, that should be, I mean, the other minutes, Shelley was good with all that and everything else, and all of a sudden, because she got rushed on this one and behind, just needs to go back and look
So
at it.
you want full names where it says Cheryl, you want to say
It should be
Cheryl Hollinger?
Mr. or Ms. or
No,
whatever.
just say
yeah.
Cheryl Hollinger like it does in all the other minutes. Doesn't have to say Ms. Cheryl Hollinger.
Whichever way.
All the other minutes just have me down as Cheryl Hollinger.
Yep, be consistent. And the only other thing I have in here is on the third page, last full paragraph under the Kimball Farm. Starts Rod Stewart stated he does not want another 40B, yada, yada. Second line down, Cheryl Hollinger will deny, wants to put down.
Where are you looking?
That doesn't make sense.
Last full of Rod Stewart.
Last full paragraph, third page.
Third page.
Okay.
Just says state he does not want the 40B, but
Will
needs.
deny wants to put in the town. Doesn't make sense. It just needs to be reworded.
Were you saying that if you denied, it would put the town?
Well, this looks like a poll. Rod Stewart stated he doesn't want another 40B, but needs something to happen to the property. He would vote for 1 year, not 2. Alan Bell also would give 1 year. Cheryl Hollinger would deny, as she wants to put the town in control.
And believes this is an ideal spot for a friendly 40B.
Yeah, fine. And believes this is an ideal spot for a friendly 40B, okay?
Or at the time, I think I said, or elderly housing.
Yeah.
Yeah, can we add in that, please? I'm pretty sure I did. Ideal spot for a friendly 40B or elderly housing.
Okay.
Back
Anything
on
else?
page 1. 18 Washington Drive, the one, second paragraph down, starts as Vice Chair Farnsworth, et cetera, et cetera, et cetera. Read down to 3, fourth line. Michael presented a copy of the new house plan. Cheryl asked if he had to come back for budding lots.
Yes, because I did
Asked if
ask.
he would come back for.
No, if
No,
he
if
had
he
to.
had to.
The other, did the other abutting lots need variances too?
Okay.
And that's what she asked.
Continue, Vice Chair Francis stated that the board could only address this petition, period. Next, these septic systems are better in the rear.
No, that's still you saying it. So semicolon, not period.
Okay, we call it.
Anything else?
No.
Everybody okay?
That was a tough one. I'm not sure we did the right thing there. Can't revisit it.
Who wants to move it?
Make the motion, we approve as amended.
There's an awful, can we review them after they're amended, please? Because there's an awful lot of changes here.
Pardon?
Okay, he's changing the words Michael to Michael Field, and he's changing one sentence in the back. That's it. Motion to approve is amended.
Second.
Who made the motion?
Needs a second. I made the motion.
Who's making the second?
I'm waiting for it.
Oh.
I'll second.
John second. All those in favor signify by saying aye.
Aye.
All opposed? None. It would be
Decision writing.
I know, it would be real helpful if the minutes were read before the meeting, so we can do them fast like
Yes.
this, because we were slipping and losing ground. Now we're pretty much caught up.
I'll go through, I know Shelley's got a lot of stuff going on, but if there's some way through her office or some help or whatever else, we can get these, trying to go back to January and figure out what happened and what was said, and, I mean, I can't remember that far back. I mean, even had a trouble with the May meeting.
I'd like to move to close the hearing.
No, we have to assign the decisions, and then we can close them. I'll take your motion.
And an email was sent out to everybody, and I had just one response as a question, but no response. A couple months ago, I passed out copies of the rough draft 2 decisions, and if any comments, suggestions, et cetera, again, an email was sent out and says, has anybody got any comments, suggestions, or corrections? I have received none. So do I presume that this is okay, we'll go with it?
They're on the
Yes.
drafts? On the drafts that you sent around for review. Let's start working with them, and if they prove to have problems, we'll modify them as we go.
Okay, then I will send to Shelley, and she will send to everybody an electronic copy that you can use as a format to go through. And if anybody does the
Jeff, I'll
case...
take them, they're all similar.
Huh?
I still owe you one, I know, but I had to get the minutes, she just gave me the minutes.
Oh, the one.
The one Shirley threw, but she gave me the minutes for it, and now I
Are
can
you
do
still
it
doing
from
the one
that.
I didn't do?
No. No, but she.
Now I'm
all
guilty,
set.
feeling guilty again.
And if anybody
That's for a
wants,
week.
no, I think, Jeff, I don't know, do you keep the decisions
do.
electronically?
Well,
Right, and
I'm
also
pretty sure
too-
I'm not the only one.
And also too, if you do one for a non-conforming lot like we did tonight, if you want a copy of a previous decision, you get it from Jeff, or I can send it to you. But I find, I pull those up, but I just changed the specifics to the case, and all the information's still right there.
One more comment about the filing of the decisions. It appears that, Bill, you did get a determination that we have 100 days from the original filing.
For a variance, a variance?
For a variance.
Yeah, for the Allen case and everything else, I was back and forth with town council and whatever else, because of my schedules and everything else, and the technicality of it, back and forth with town council, could not get it to Jeff within 14 days, exactly. But as town council says, and he reiterated what I have said for a long time, that is not mandated to have it within 14 days. The only thing with the variance is that you're mandated to have the decision filed with town clerk within 100 days of filing, which we were well under that. And even the state guidelines about the 14 days is in reference to that 100. So that says if you get it close to the 100 days of filing, you better have your, from the time of vote, don't get it too close to the 100 days so that you can't meet the 14 days at that point.
Shelley wants you to leave
So-
everything in that box behind you.
Now, the question really came up because the Allens were, Mrs. Allen was in checking with Shelley almost daily as to where is it? And we wanted to make sure that there was no problems with the filing of the decision, so.
The day we had it ready to file was election
Election
day,
day.
so Diane wasn't in the office, so.
And you can't file if the town clerk's not in the office. So anyway, town council did clarify that, so we're all set with that.
I move we close the hearing. Have the
Hearing
verbs.
or meeting?
Meeting. Thank you.
Second?
Give me your clips for Shelley.
So I have.
Second to
Mark's
close.
gonna second.
I had this.
I'll second. No, I'm not a voting member, I'm supposed to.
John?
I'll second.
All those in favor?
Aye.
Opposed? Thank you.
Hey, Patrick, can I have your clip and your